but anyway.
No problem. Hi, everyone. It's a pleasure to start another panel of the 4th International Conference, annual conference of the IBCI. This time discussing IP, and have the luck of being with two excellent professors. Professor Rita Matulionyte from Australia. It's a pleasure to have you here. I know that you had an effort, even if the time zone should be here at this time. And it's an honor for us. And Professor Paula Forgioi, that's a full professor of the USP, University of São Paulo, and she is the main inspiration for generations of scholars in competition law. And I learned her book about the foundations of antitrust, as many others, and she is a great friend of the IBCI, and she gives a lot of support to our institute. So it's really an honor to have you here. We're going to start by Professor Rita to explain, then we're going to go to Professor Paul. So Professor Rita, thank you very much, and the word is yours.
Thank you. 1 second, I'll just start sharing my slides. They were just here, now they disappear, my slides. Just hold with me. I'm not sure what happened there. Apologies, just trying to, here they are. Okay, well, good morning here from Australia. It's my great pleasure to be to participate in this very interesting conference. Thank you very much for the organizers for your kind invitation. So my name is Rita Matulionyte, and I'm at Macquarie Law School here in Australia. And today I want to talk about artificial intelligence, innovation in artificial intelligence and intellectual property law, with a bit of focus to developing countries, developing world. So as some of us might already have heard, we are entering or have entered the 4th industrial revolution. If you look at this slide, we can see that previous revolutions were fueled by such technology as electricity, computing, and now the newest one is arguably being fueled by artificial intelligence and other similar technologies. Artificial intelligence technologies are supposed to contribute immensely to the world economy. So, for instance, under PricewaterhouseCoopers report, it will contribute up to 15.7 trillion to the global economy by 2030, which is more than the current output of China and India combined. Now, artificial intelligence technologies are already being adopted in many different sectors and have great potential to improve people's lives. So starting from relatively simple technologies such as the Google Assistant or online recommendation algorithms, artificial intelligence technologies already creating works themselves, like this particular painting. AI is being increasingly used in medical sector, in healthcare, in pharmaceutical sector to help develop new products and improve medical healthcare services. And it's also being increasingly employed by state authorities such as law enforcement and others. Now, certainly, we have to highlight that these technologies have both opportunities and immense challenges. So you might have heard that there are a lot of ethical as well as legal issues related to employment of AI technology, especially in public sector. But today we want to really focus more on opportunities. And looking from that side, we want to ask to which extent current laws, and especially intellectual property laws, are adequate to promote innovation in AI technologies that are going to, or hopefully will improve our lives in the future. Now, what I want to do in this presentation, I want to overview the current international debate on this topic, because I understand that the audience is not necessarily familiar with this debate on IP and AI. And also then ask a few questions about how this debate could be framed or could be addressed in a developing country such as Brazil. So, the question of whether IP laws are adequate in the current or in the age of AI has been addressed at different fora. So I think the first consultation that was on this topic was by U.S. Patent and Trademark Office, where they ran consultation on AI and IP a few years ago, and then it was WIPO, World Intellectual Property Organization Dialogue on AI and IP, which they already had, I think, 4 sessions on the topic, and UK consultation in the area. Apologies for the type on the slide. So UK had ran the first consultation around, I think, last year, and now they announced the second consultation where they're looking on 3 selected questions with a view of probably doing kind of with a view of reforming some of the provisions. So when we talk about AI and IP, we normally talk about issues with copyright law, patent law, and to some extent trade secrets law. So I'll look at each of them now separately. So the first issue that AI technologies raise in copyright law's field is so-called text and data mining or machine learning problems related to copyright. So, for instance, as an example to demonstrate the problem, a few years ago, Google used 11,000 romance novels scraped from the Smashwords website to feed and train their machine learning algorithm, or so to say, to teach their Google Assistant to talk in a more casual way. Now, this was done without authorization right holders, and the question that arose: to which extent this such use of copyrighted works infringes copyright, or is it legal under current law and should it be legal? Of course, especially US right holders were quite surprised and not necessarily very happy about such use. There was no case, so we don't really know the answer. The next example to demonstrate the problem could be this beautiful painting. So this is a painting from so-called New Rembrandt project. And in this case, it's often used in presentations in AI and IP. And in this case, let's say the AI developer used many or all Rembrandt paintings to train their software and algorithm, and this algorithm produced this particular painting. So again, pre-existing copyrighted works were used in the process. Certainly, they were not protected anymore because the copyright protection expired to this with relation to these particular paintings. However, it shows the capability of AI technologies, to be kind of pre-trained with pre-existing copyrighted works, and then to produce other copyrighted works, which might actually even imitate the style of authors who created pre-existing works. Now, so the question is such use of copyrighted protected content machine learning process legal, or does it require authorization from right holders? So we might know that under WIPO, a copyright treaty, as well as performance phonograms treaty, that we have a very broad so-called reproduction right, which covers essentially all digital reproduction rights. And this which covers digital reproduction, in addition to analog reproduction and even temporary reproduction. So this very broad reproduction rights were transposed in most national laws. And now in some countries we have fair use exception, so in US, Israel, South Korea, and a few others, which arguably at least covers at least some so-called text and data mining uses, or which also cover machine learning uses. So previously we had a lot of discussion about text and data mining but now we moved more into kind of the technology has changed, and we're talking more about machine learning, let's say, process which overlapped with text and data mining to some extent, though they're not identical. Now, one of the examples how fair use could allow such uses is Google Books case. So in this case, Google Books scanned and digitized millions of books and created a Google Book search engine. And the US courts found that such uses, which allow online, let's say, internet users to search that Google Books engine and receive links to snippets from those books, is eligible under fair use. So while this is not a machine learning kind of project, it also it concerns the use of huge amounts of pre-existing copyrighted works and process them through certain text and data mining techniques, which to some extent, similar to machine learning process and issues that it raises. Now, other countries, understanding there might be a problem with copyright infringements as far as machine learning and other AI technologies are concerned, have introduced text and data mining exception. So, for instance, in the EU, UK, Japan, and I think in South Korea, there are specific exceptions that cover copyright exceptions, right? That cover the use of works in machine learning, and similar technologies. Now, in some countries, these exceptions are overly broad, and they cover both kind of commercial and non-commercial uses. In UK, for instance, it was the first country that introduced this exception a few years ago, and at that time they were able only to introduce text and data mining exception for non-commercial purposes. So only universities, research institutions, and so on can use copyrighted works for let's say text and data mining or machine learning purposes, but it doesn't apply for commercial bodies such as Google and others, or any AI developers. Now, in many other countries, or in most other countries, there is no special solution yet. So in most other countries, the answer is we don't really know whether use of data or copyrighted data in machine learning process that is essential in developing AI technologies is allowed under copyright law or not. So what are the possible solutions? And there were two solutions that have been discussed, but of course the focus has been mainly on exception. So do we need an exception? And if so, do we want to introduce a fair use exception or text and data mining style exception in the laws, and also if we want a text and data mining style exception, would it be commercial, non-commercial, for non-commercial purposes? Now, there has been also a bit of discussion, especially the call from right holders, that of course they were arguing we do not want exception, we want licensing approach. We want to make sure that if our data or if our content is being used to fuel those AI technologies, well, fuel is not for free. So somebody has to pay for fuel. And that's why they were suggesting that that content should be licensed. They have to be paid for when their content is used to train AI technologies. Now, in my paper that I've just cited below, I'm looking at different options, and I'm quite understanding of the demands from creative industry, and I try to explore also collecting licensing approaches, and unfortunately I find that it's very difficult, if not impossible, to create collective licensing, reasonable functioning collecting licensing schemes where collecting societies would be able to collect fees from, when content is used for machine learning purpose and distributed for right holders. And this is some sort of kind of market failure, which probably would be best addressed via an exception. Now, the second issue that AI technologies raise in copyright context is so-called AI generated works. So, for instance, Washington Post has been using a so-called robot reporter, a heliograph, or essentially AI technology that was producing and publishing articles. And so in the past year, it produced 850 articles without, so to say, a human intervention. So such so-called AI-generated works, should they be protected? Are they protected? And who is the owner and who's the author of such works? Now, so another example is, for instance, the song by Uncanny Valley, the Australian band, was called "Beautiful the World," which was produced for Eurovision AI Song Contest in 2020, and it won that contest. So this song was arguably produced by an AI algorithm without a human intervention. Now, of course, algorithm was developed by a human, it was trained by a human, it was calibrated by a human, but at the end, the output that was produced arguably was created by an algorithm. So again, where is such machine produced work protected under current copyright laws? Should it be, and who owns or should own it? That's a question that's being asked in international and national debates on AI and IP. Probably that's the most somehow hot topic that's being discussed for some reason. Now, the same question could apply exactly to the same painting that I just showed before, which is next Rembrandt project. So this painting was produced, as I said, by machine. So is it protected, and who would own it? So the questions, so this question again is not really answered in most jurisdictions. So in the UK, there is a so-called computer-generated works provision that suggests that works generated by computers are protected, and they are owned by the person who made all necessary, I forgot now the exact formulation, but something like made all necessary arrangements to produce that work. And however, this provision was introduced, is it over 20 years ago? So when AI technology did not, so to say, as we understand it today, did not exist. And so even UK office and stakeholders discuss intensively now whether this provision is really suited for now in this new generation of computer-generated works. And this provision has been also implemented in a few other countries, like New Zealand and I think South Africa, or a few other common law countries, but in most other countries there is no provision. And for instance, in Australia, some case law very explicitly says that if work was generated by software without a possibility to attribute or identify a clear original contribution by human beings, then it would not be protected. So the question that we are asking, do we want to protect such works? And if so, who owns it? And possible approaches would be, we don't need protection at all, because we want to incentivize human innovation. We don't want to incentivize machine innovation. And while we need to incentivize maybe, or we want to incentivize innovation into developing such machines, such incentives are given by granting IP rights over such machines, over AI algorithm, or over a patentable, software implemented inventions, and so on. Now, other approach, which is probably more prevailing, is that we probably want to protect AI-generated output. Now, the question is then, who would be the owner? And that's been discussed a lot. And we have a few different options. One is the developer of AI, the company, the person that developed AI should own also all the outputs generated by AI as a default rule. Of course, this could be changed by a contract. Another option is the user of the AI should be the owner of AI. So if you, let's say, kind of have an access to the technology, and and then you use that technology to create the work, then you should be the owner. So an example could be the Google Magenta software that's available freely online for musicians to generate music. And then so when musicians would use that software, which is given, licensed for free by Google, but is to a certain extent. So the argument would be that the musicians would own the outputs because, well, they certainly had to actually still input quite a lot of effort to calibrate that software in order to to get the outputs that they want. So there was sufficient contribution to justify ownership of works. Now, A final option, which actually kind of has been maybe raised more recently, is that the owner of AI is the owner of should be the owner of AI generated works. So this comes from this idea comes maybe from the patent law field, and I'll discuss that maybe a bit later. But essentially, in our most recent article with Professor Jihan Li from Chinese University of Hong Kong, we argue that maybe awarding ownership of AI generated works to AI owner might be actually the best solution. Okay, let's move then now to patents law, and this to this Davos case that I've just mentioned a second ago. So in patent law field, we have a number of different issues related to artificial intelligence technology. So we have issues with inventive step. We have issues in trying to now define the person skilled in the art. But one of the most somehow now popular issues at the moment is the one that already we discussed in copyright law. That is whether AI generated inventions should be patentable, whether we can list AI as an inventor, and then who should own such inventions. And these questions have become especially popular due to the Artificial Inventor project. Now, this project was started by Dr. Taylor, who is an AI scientist, and a team of patent attorneys in US and UK. And essentially what they did is, so arguably this AI technology called Davos, developed by Dr. Taylor, has invented these two technologies, which is brain mimicking light and a fractal container. The team has applied for patents around the world, listing AI as an inventor. They wanted to check whether current patent laws allow actually patenting those AI-generated technologies and AI-generated inventions, and whether they allow listing AI as an inventor. Now, so far, there have been 16 applications lodged around the world, including in Europe, UK, US, Australia, and New Zealand, and in some Asian countries. I'm not sure in Latin American countries if there were any applications. Now, many patent offices have rejected these applications, including in UK, US, German, European Patent Office, IP Australia, arguing that AI or any non-human cannot be listed as an inventor. Now, there were then appeals were lodged with a number of courts, and most of the decisions were upheld, like in US and UK, courts upheld these rejections with a few exceptions. This year, South African Patent Office granted a patent over inventions that are arguably generated by AI. And so to say, they saw no problem with Davos being listed as an inventor. And in Australia, Federal Court of Australia, to surprise many, they also upheld the appeal and suggested that, yes, under Australian patent law, it should be possible to list AI as an inventor. Now, this case is not yet final. Now it is pending before full federal court. So we still don't know what's really the situation in Australia. But the interim result that that AI can be listed as a inventor. Now, it's worth, of course, noting that AI would not be the owner of the patent. So it's been even the applicants agreed that. The AI owner would be the owner of the patent, but it's only the question is whether AI can be listed as an inventor. So we're not creating any rights essentially to AI, but just kind of attributing them, or at least we're giving a moral right for the AI to be attributed as an inventor. So issues that been raised in this context is, first of all, is the AI capable already of autonomous invention, or is it still AI as a tool, even if a sophisticated one in the invention process? So there's been a lot of argument that maybe the autonomous inventiveness capabilities have been overstated. And while AI, automates processing of huge amounts of data that leads to certain outcomes, it doesn't mean that they are inventing in a sense that how we understand it. So maybe we don't have really AI generated inventions. We just maybe have still AI assisted inventions. And that's actually the approach with which I agree. And so then assuming that we already have or will very soon have inventions that are autonomously generated by AI without human intervention, should we protect such inventions? And if so, who should be the owner? Similar questions as in patent law, as in copyright law. Now, and as we saw, courts do not agree, or maybe like most courts seems to suggest that at least currently patent laws are not adapted to address this issue. At least they do not allow AI-generated inventions. And in my most recent publication, which is still pending under review, I argue actually that I followed the approach adopted probably by most, that AI, while it is a very sophisticated and technology is capable of maybe sometimes processing more data and a speedy process than a human brain, it's still not autonomous sufficient to talk about AI-generated inventions. And we still should identify human beings, however difficult it is, who contributed to that invention, and they would be the inventors and eventually the first owners of invention. Now, the final point that I want to raise here is AI and trade secrets. It's much less discussed, but I wanted to just kind of raise because these issues and to popularize them a bit more, because I think trade secrets also have a few issues with relation to trade secrets and AI. So we might have heard that there are those number of ethical principles adopted around the world that require AI to be transparent and explainable, especially when they're used in high-risk contexts, let's say law enforcement or judicial proceedings, administrative proceedings, and so on. At the same time, there is a risk that trade secrets inhibit the transparency and explainability of AI, because AI developers often keep their data sets, their algorithmic parameters, and other secret, and for other stakeholders, it becomes difficult to get access to these parameters and try to understand how technology functions. So if you say the algorithms such as COMPAS technology applied by US courts to assess the recidivism of defendants, they kind of, when it's used, the defendants might want, and some of them really wanted to understand why technology reached that particular decision, how it's been developed, what criteria have been used, and what parameters have been used, and what weights were given when they asked to get access to those algorithmic parameters. They were denied access because of trade secrets. So there has been an issue raised that trade secrets actually inhibit this ethical AI, which we need to discuss a bit further, I believe. And a similar question is a similar issue that has been raised, at least by some right-holder organizations, is that trade secrets inhibit enforcement of copyright in machine learning contexts. So as I talked before, copyright content can be and is being used to develop, let's say, AI modules, but right holders cannot know about that normally because data sets are never or almost never disclosed to public. So they can't know when their works have been used in machine learning context, and they can't then, if there is if such uses are illegal under local laws, they can't enforce those rights. So one should think very carefully how we overcome this lack of transparency issue in AI, and whether trade secrets need to be addressed as a problem. Okay, so I've kind of finished the overview of this debate that's going on around the world. And what I want to the question that I want to raise is how this debate needs to be, should be addressed in a developing country such as Brazil. Apologies. So I certainly don't have any answers. The one thing what I want to do is to draw the attention to the problem that developing countries are underrepresented in this current debate on AI and IP. So when even if, let's say, WIPO, in a WIPO dialogue, we see a few people coming from developing countries talking about this issue, I think it's really not yet well understood to which extent, what IP laws are needed for developing countries to foster their indigenous innovation in AI technologies. So if AI technology is the one that would drive forth revolution, developing countries really should be thinking very carefully what legal framework is needed to support innovation and not inhibit it. So some of the questions that might be asked is, so of course, what potential AI has in a developing country to start with, and if the developing particular country like Brazil, do they prioritize AI as a technology that they want to develop and export, or rather they their priorities are elsewhere and they will be an importing country? So then you would have to think about the answer then as far as IP framework would be different. Or another question is, so then the question would be like, what national international IP framework would be most suitable for that country? So depending on whether you are an importing country of technology or develop and exporting country, you might need weaker or stronger IP protections. And I already understand from Paula, who will be speaking next, there is a big debate about IP relevance for developing countries such as Brazil. So I'll really look forward to listening to her views on that topic. But I raised here just a few questions to start the discussion and encourage the discussion. And yes, if you are interested in this discussion, I would encourage you to approach me and and explore the issues and collaboration opportunities. And if you need more information, these are a few articles that I've published on topic. So you can take a look, and we could continue our discussion some other forum. Thank you very much. And any questions would be more than welcome.
Thank you, Professor Rita. It was a very insightful presentation with the broader view of the debating international landscape and the approach to Brazil. So it's our honor really to have Professor Paula Forgioi here. So the word is yours.
Thank you, Vinicius. It's a pleasure to be here. I would like to thank you a lot, Vinicius, and to thank Professor Eduardo Gaban too, and IBCI for inviting me. It's really an honor and a great pleasure. And I do thank you, and please accept my compliments, because you are really doing a great job here in Brazil in this field of technology and law. It's well done, really well done. Professor, we are in Brazil, we have already said this, so I will call you Rita, if you allowed me. So Rita, it was a very insightful presentation, and I do think that we have a lot of points in common that we have to discuss. I will bring few information, then Rita here, then Professor Matulionyte. But I would like to stress some points that, taking what Professor said, that we from developing countries, we have to discuss this. We have to bring our problems into the sun, because we have to discuss it. And I do agree with you, Rita, that we are underrepresented in this discussion all over the world. So I will try to bring some ideas that I would like just to think and to discuss, because they seem to me very seminal problems. The points that we have to start back to the basis. Okay, so let's think from the beginning. It's useless to say that not only the world changed, our lives changed a lot during the pandemic. And well, I would like to stress two main things, not only our lives, the world, but two main things that are very important when we think about digital markets. The first one is distribution system. Distribution, I love distribution. I think is one of the most important things in the world for the economy. And we are having huge changes in distribution systems all over the world. We haven't understood yet what is happening. We still don't see all the changes. We are still observing everything changing. So the first point that I would like, sorry about that. The first thing that I would invite everybody to think of is distribution. It's completely different. What we have now is completely different from what we had 2 years ago. So everything changed. The structure of the system changed. Okay, so the power is distributed, or is being distributed in another way now, and we have to understand what's going on with this. First point. The second point are services. It's another thing that changed a lot during the pandemic. So services that we have now in our computers. Let me give you an example. My eldest brother is without internet. He had some problems yesterday with his internet. I mean, he's facing a lot of problems. His life just stopped 2 days ago, and he's trying to solve his problem, but everything stopped in his life and in his house. Okay, so he's not working. And I just, when I saw this, I just thought, wow, everything is depending on the screens that we have before us. So it's very different, again, from what we had 2 years ago. So what are we going to do? Are we going to do something? Because what we see here from the third world, what we see is that things are just going on. We have a lot of seminars, a lot of professors discussing, but what are we doing? What are we really doing to try to deal with all those problems that we have? And I should say, no, we are just observing and we are doing nothing. Things are going on as they want. I mean, we have a lot of determinism in this. I see that we are discussing Schumpeter here too. And, you know, sometimes I think that Schumpeter is just looking at this situation and laughing a lot, because we are just watching the power concentrating a lot, and then just watching and waiting for the wave to end. We are just waiting, just like Schumpeter used to say, oh, we are talking about disruptive competition, etc. Something is going to happen. We are going to have another technology. And in the midterm, everything is going, all the problems are going to be solved. Even the Roman Empire fell. Okay, everything finished one day, but at what price? Especially at what price for the third world, for poor people. Not only the third world, but poor people, even in the first world, because we have in the first world too. So maybe we are believing Schumpeter too much. Maybe we are putting our eggs in this basket, in Schumpeter's basket. Maybe. Okay, but going back, I have 30 minutes, is it? I'm going to finish at 5, more or less. Is it, Vinicius?
Yes, but if you want to go like for more minutes, no problem, Professor Paula.
Okay, thank you. You're very kind. You're always very kind with me. Thank you. So talking about, I should say, two problems. Distribution systems. We are facing problems with the real world and the virtual world. Okay, everybody knows that the sales, online sales, are increasing a lot. So we are concentrating this power in very few companies. We are concentrating in Amazon. We are concentrating Americanas, that you people from Brazil know very well. In Americanas is doing a lot of things, Magazine Luiza, but everything is concentrating a lot. Mercado Livre, you have some structures that are big, some platforms, the technical term is platforms, that are increasing a lot and that are concentrating even more power. So what are we going to do about that? Again, the problem that we see now, concentration of power. But we are not talking only about M&As or buying everybody, etc. It's not this problem. We are talking about concentration, and we are doing nothing about that. The second point, services. Everything we buy is we buy a lot of services, and then we are going to finish at the problem, technology, property rights. We are talking about concentration, not of bricks. We are talking about concentration of property rights. And I'm not wrong if I say that this is the intellectual property rights are the most important kind of property that we have now. You cannot, it was this way 2 years ago. I have no doubt, but now I think nobody can deny this. The most important kind of property today in the world, because of the pandemic, because of what we are living now, the most important kind of property is intellectual property. And intellectual property is a fiction, okay? It's only law, it's just a fiction. And it's a fiction that is working very extremely well to concentrate even more power. And I think an ET that could arrive today in our planet would look at everything and said, wow, they are really crazy, because everything is a fiction. They create things, they create institutions just like property, intellectual property, just to assure the exclusivity. So if something is an object of the property, as we say in civil law systems, it's the object of the property, it's exclusivity, it's exclusive, because properties are exclusivities. And then only one person or only one firm, etc., no, whatever, only this person can take money from that. This is a good, as Marx would call it. It's a good that circulates because you have the property and it's exclusive. So nobody can touch it. It's the supreme property. It's the supreme right, the most powerful right that we have in humankind is used to assure, to give that property, that's a fiction, to some companies. That's how it works, okay? We are all talking about fictions that concentrate power. I know there is the other side of the coin. I know, of course, all the arguments that say that we need this to have innovation. Do we? Maybe yes. But do we need it so much? Do we need it so deeply? I have doubts. And we go to another problem. There is political, that is political and ideological. you cannot say, it's very interesting because you have all the propaganda in favor of property rights, okay? You try to isolate the critic about the property rights, and the mainstream, all the universities, scholars, and publish or perish on property rights. The mainstream says that we need strong property rights to develop. Where are the proofs of this? We don't have evidence of this effect. Again, of course we need it, but how much do we need? Nobody knows, but everybody says that we need it a lot. And we are not talking about this seriously. Sometimes you hear one person here, there, or the critics are in the third word, so people don't listen to us. Rita, this is incredible. We have a lot of very good people in the third word thinking about it outside the Eve League, okay? We're thinking about it, we are discussing this, and we don't have places, we don't have our spot in the international theater that is going on, talking about IP and pandemia and power and development and innovation. And even here in Brazil, the mainstream says, no, we have to protect it a lot. We have the main law offices working for the main companies. We have some very clever work with our courts. I mean, even trying to train our judges here. We have some movements saying, no, we are going to teach you the best practice to protect property rights. We are not talking about bags. Okay, we're not talking about bags or shoes or trademarks in this sense. We are talking about patents. We are talking about medicines. We are talking about concentration of power. We are talking about democracy, because controlling the technology today is controlling democracy. We know that. I mean, the second point is not only the concentration of power, but the problems that we have with democracy. I can say, no, you will not listen, we are not broadcast maybe one president. No, we are not broadcasting him. Really, I don't want to discuss this, but what is very interesting to watch is that a private company, because these private companies dominates the channel, okay, the way the broadcast says, no, I'm not going to give you the floor. This is very strong. This is very political. This is very complicated. It impacts a lot democracy. And nobody's discussing this because maybe I don't like that politician too. But the problem is not the politician. Believe me, I live in Brazil. The problem is not the politician. The problem is the power of controlling this. I'm not saying that this is not a problem, but I'm more worried with the big picture. Because, you know, presidents, you are elected and they go on just like a big brother, you know, people go on, they come and go. But the point here is democracy, and everything is linked with property rights. And we humans are very clever. We try to convince ourselves, and we convince the others that we are dealing with a technical problem, IPRs. It's just technical problems. Let's see the grades that we want to, the amount of property rights that we want to have. And the problem, again, is not technical. It's technical, of course, but it's political. And nobody's doing nothing. Again, I'm going back to the previous point. Nobody's doing nothing because maybe nobody wants to do anything because we don't have regulation, or we have very few regulation, or I know we have some regulation, but okay, we are playing with democracy, with a concentration of power that humanity has never seen before, never. A completely private power dominating all the communication and dominating all this scenario, dominating all the system. So it's not, maybe it's not wrong to conclude that nobody's doing nothing or everybody's doing very few, because nobody, or it's better doing nothing, because everything can stay the way it's today. Okay, it's very simple. We have the technical, it's only fictions. These fictions lead to concentration of power and problems of democracy, and we are doing nothing about it. As Rita said before me, where are our voices? We don't have voice. We from the third world, we just don't have voice. We love traveling, going to seminars, etc., but nobody really wants to listen to us. It's the impression I have from here, from University of São Paulo. I mean, I guess that Vinicius from Federal do Paraná has maybe, I'm not talking for him, but maybe he has the same impression that I have as a professor, a Brazilian professor. Nobody wants, we are maybe very, how can I say, eccentrical or something like that. And nobody takes seriously what we say. Okay, and then to finish this first discussion here, we have the problem of consumers' dependence. It's not only a matter of political power, but the dependence of our consumers. We are not in our best moment here in Brazil, of course, but we are a huge and very rich market. If you look at European market or even to American markets, they are mature markets. They have already given to us what they could have given. Here we have the possibility of sales, that it's incredible. We have a huge market and we know that. So our consumers are completely dependent of this technology, of this fiction that PR is. I was going back to the point, back to the basis, distribution and services. I'm not talking about patents because Vinicius invited me to talk about digital markets. So I'm not talking about medicines, okay? I'm talking about distribution and services. And our consumers completely dependent of this technology, of this PR, of this fiction that is completely unregulated. What we have in here in Brazil is, for instance, our Secretary of Consumers, Juliana Domingues, just running to try to protect what we call consumidores vulneráveis, trying to do something to protect this kind of consumer. But it's a very unfair battle that Juliana, for instance, is fighting, because we don't have instruments. We don't have even political conditions to go against the giants, the 5 giants of the world today, Google and Microsoft, and everybody knows Facebook, and all the problems that we have. Look, I'm not talking about communication. I'm not talking about patents. I'm just medicine patents. I'm just talking about distribution and services. So that's it. Just to start our discussion. Thank you again, Vinicius, and thank you, Rita, for listening to me.
Thank you very much, Professor Paula, for your brilliant reflections on the subject. It was very good and very insightful. And I want to, before passing the word to Rita, I would like to ask a question for her. And then after, maybe, how the incentives of the patents do you think change with AI? Because one of the things, I don't know, in Brazil law at least, it's that after some time, you can reproduce the invention. You can have public knowledge of the invention. And if it's an AI, it's strange. And it's, I think, the last slide of you, like if you have a trade secret, or it's like opaque to the benefit for access of the invention. How do you think AI changes that? The way this invention, after it expires, it becomes available to all, but I don't know if it don't have the software that produces the invention. I don't know. There is no point in allowing everyone to have the idea of the invention or the scheme of the invention. And how do you think that that goes?
So is that the question to me or to Professor Paula?
No, to you. To you, Rita. You can react to Paula's speech and answer my question if possible.
Okay, thank you. Thank you, Vinicius. So I suppose, I think the current discussion around AI, I think a bit exaggerates, I think, that image of AI. And I think AI will not change that, like as far as patents are concerned, the situation that much. From my perspective, I think, yes, AI is a new sophisticated technology that helps develop innovations, but still innovations are developed by humans at the end of the day. And and using AI as a sophisticated tool, maybe that we didn't have before. And then how they choose to protect it, either patents or trade secrets, I don't know whether the balance will change, like which type of protection is chosen. And then, also, I'm not sure whether, it will affect, this public domain that you're referring to. So it's even if in pharmaceutical industry where there is a lot of investment in AI, and AI is being extensively used, not only pharmaceutical, but healthcare industry, to create some innovations. These innovations developed with the help of AI might be patented, and then, when patent expires, they become disclosed as before. If in some instances, or a part of innovation will be, or entire of it will be protected by trade secrets, which used to happen before, well, then it won't be disclosed to the public until either company decides to disclose it, or they are disclosed, without the intention of the company. Like trade secrets are also have a limited protection, because you can't protect every technology with trade secrets. Technologies that are reverse engineered, it can be reverse engineered. They simply, and you put, there is no use of protecting with trade secrets. So, I mean, yeah, I'm not sure if that's the question you are asking. Maybe I'll just add one more point. I think in this Davos discussion, there is a big argument that we need to protect AI-generated inventions by patents, because or give a possibility to protect by patents, because if we do not award patents to AI-generated inventions, then these inventions will be kept as trade secrets, and then public won't have access even after 20 years and so on. But I think this is not necessarily a very strong argument because of the actually limitations of trade secret protection that I've just mentioned before. So for instance, even that technology that Dobbs arguably generated, that brain mimicking light and this fractal container. Now let's imagine, patents are not granted over it because AI is an inventor. Like, do we want to protect by trade secrets? Well, we can't, because whenever we put those technologies into market, they can be easily reverse engineered. So there is, trade secret protection is not possible for them at all. So and other competitors, they just, can figure out how this was fractal container is produced and just can't copy it. So trade secrets is of no use, and that even if patent is available, like the technology will be not locked as secret. So it's not an issue. And also there are other trade secret limitations, such as, difficulty in keeping them secret and third-party disclosure and so on. So essentially the answer to your question is, I don't see, anything much new as far as AI technology is concerned. I don't, some technologies are likely, to be patented, others likely to be trade secret, others might be, released to public and, commercialized without exclusive rights by leveraging, I don't know, first, that what do you call in competition law? The first who comes in the market, reaps the benefits.
Like the economy of the first result, something like that.
Yeah, that's right. I suppose that will still be very important in many situations.
Okay, thank you. And Paula, I agree with you that were underrepresented in the debate, and I agree with you. And I think in some lot of areas, I think Brazil is just waiting how other countries will regulate, like in United States. Then we do something like after that. The thing. Maybe that's because we are not in the first world, and we want to see that could have some benefits, like waiting for the results of other initiatives. But in something like intellectual property that has a lot of international norms and international rules, that's going to be dangerous, because if you have some regulation in the international arena, maybe there is no space for us to change that. So do you think we should do different? Do you think we as Brazil should try a new way of doing things, like try to do something different first?
Well, Vinicius, I think that it was a very good beginning that our STJ, it's not Superior Court, it's not the Supreme Court, it's the Superior Court, started to change the way they see trips, for instance, okay? So we had in the last years very important decisions against the big industry of drugs, for instance, that maybe could signalize a change on this, maybe. Okay, it was a very good beginning. We have some important cases pending on our Supreme Court, on STF. We had a very important decision some months ago about patents, and we are changing the way that the courts deal with the problem. Because we used to because big companies have the best lawyers in the world, we used to have great decisions in favor of big companies. Now we are starting to change some things, okay? I think that we should take care mainly of our court decisions. We should take care of the agreements and consent degrees, but mainly agreements that we are having in some private suits. between that deal with property rights. It's very dangerous, and nobody's taking care of this. I think the problem is not the main problem now at this moment. Or the problem is so big that I would start taking care of this, taking care of our court decisions, taking care of our interests, or interests that are not only those from the big companies. I would give resources and money for the public minister, public officers to make their job, and to take care of the capture of those our agencies. That it's a huge problem too, because our agencies sometimes they work for big companies. I'm not talking about corruption. I'm talking about all this that we know, the phenomenon of capture and things like that. So I would start that way. I think that we have to take care of our interests. And then and at the same time, we have to talk in international forums. Sometimes I talk and people from Petrobras start to telling me, be quiet. Remember, we have a lot of patents. Brazil, we have our interests in patents too. Okay, but we have to go to this arena. We have to talk, and we have to give our diplomacy weapons to fight and to show the world our point of view. But I think we have a lot of work to do, intern job that we have to do here in Brazil to start. Okay.
Okay, thank you very much, Professor Paula. So, Professor Rita, do you want to say some final remarks, some comments?
I'm just curious, how much more time do we have? I want to ask one question to Professor Paula. Not sure if we have time for that.
No, you have time. Feel free to ask.
Okay, thank you. Yes, so Vinicius encouraged me to provide some feedback maybe on your presentation, and I wanted to ask a question. So I'm really interested in that in that idea, of course, that developing countries are underrepresented, and of course maybe they don't need such a strong IP protection. I myself come from the country which is a small European country, which is maybe also kind of developing country, and I often see that problem, that we are forced to follow the same laws as developed countries without really ourselves understanding what we need. And that's why your call for also job, that we have to do an internal job first to understand, articulate our real needs first before we also go into international forum to express them and demand and make our demands. I completely understand them very well. My question kind of is, well, there has been a lot of research and studies done arguing that, of course, IP laws do not necessarily promote innovation. Even in Australia, which is a developed country, but it is an actually innovation importing country rather than an exporting country. The reports have said, IP laws do not necessarily, encourage innovation in Australia. But then the recommendations still were, we can't really, abandon IP laws now. We can't just cancel all of them now. That's not the solution. So we still keep going with them. So what is the solution then? I mean, we know that IP laws do not necessarily encourage innovation, especially in developing countries. And at the same time, we agree that, as you also mentioned, that our local industries need IP laws to some extent. Do you have any ideas, how this, apart from, talking about that, more about this issue, is there any solutions in your mind that, a developing country could adopt in this complex environment?
The application of the law. The application of the law. Here in Brazil, if we had more time, I could tell you some decisions, some court decisions that we had that you wouldn't believe. I mean, it's almost impossible to believe that a Brazilian court would extend the powers, extend the time of a patent a lot, but extend a lot. And 1 year of a patent means a lot of money from our government, because our government is the one that consumes drugs, is the main buyer of drugs here in Brazil. So I could tell you I could give you some examples that you wouldn't believe. You would say, Paula, you are only joking. No, I'm not joking. So I think the first point, nobody wants to, there are people that want to abolish property rights, but we are not talking about this, okay? I would deal with a good application of the law. That's why I think that courts are the key of this equation. Courts are very important. Our judges have to understand what they are doing and the consequences of what they are doing. In the last decision that we have in our Supreme Court, about our Constitutional Court, about this, the judge said, oh, you know how much it costs for our country that we can interpret it, we can apply the law in some ways. We are choosing the worst way for our country. Please pay attention to this. The law says this, you don't have to apply it in a very huge way. Let's just a very simple thing. You have to apply it in a straight way, not in a broad way, okay? In a straight way. Just this, it changed a lot here in Brazil as orientation for the lower courts. And you know, big firms and they know that. I'm telling you, they are trying to have courses for our judges, just to teach them best practice on on industrial property rights. So we have to take care of this. I would start there, okay? Changing international agreements, it's a very difficult task, okay? But just applying our law as Europeans do or as Americans do, sometimes we are, as we say in Portuguese, more realistic than the queen or the king. Mais realistas do que o rei, because there is this legend, and again, ideology, that says that the stronger property rights are better for innovation and for our development too. So I would start there, educating our judges to apply TRIPS and to apply all the international agreements in the best way we can. That's it.
Thank you. Sounds like a very sensible approach.
I can send you this Brazilian court decisions. You won't believe in what you are going to read. Okay.
Thank you very much. So I think we have time for one more round of conversation. Maybe can, I don't know, one reflection we could have is if this change of AI, like we are changing the way, we're not changing the law, but we're changing the way the law applies and how it applies. Maybe it's an opportunity to do this flexibility, this adaptation that Professor Paula was saying, at least in this new technology. And then we can just expand and do a spillover to other markets. I don't know if you agree with that, Professor Rita.
Yeah, I think it's really good to comment and an idea, and that's the thing that's the idea that I was having in my mind while inviting developing countries to participate in this discussion, because we know, like at the times of TRIPS, developing countries were not involved, so didn't have it, like, or not sufficient involved, and didn't influence the discussion. But I think from then on, they really had a increasing role in international discussion, shaping national laws, or at least they've stopped from many, worse laws to be developed. just like ACTA, anti-counterfeiting trading agreement, I think was stopped because of the pressure from developing countries, and also from the pressure of academics and others in developed countries who were aware of problems in developing countries. So I think that's, we are entering a new, maybe a new economic kind of or stage, or I don't know, a new stage where the new technology and maybe new economic developments are there. And I think really that's why developing countries have to come on board and discuss that before already the discussion is finished and new norms are agreed by developed countries. So that if developing countries participate from the beginning, if they clearly know their interests, if they clearly articulate them in that debate on AI and IP, but also maybe AI and all different laws broadly, because AI raises a lot of issues with different laws, then those laws might be more balanced. At the same time, what issue I see here is, at least when I look from the country I come from, which is Lithuania, when I talk, for instance, with stakeholders there about law reforms in Europe, that initiatives to reform laws in Europe, they say, look, these problems that that are often raised by leading European countries like Germany, we don't have these problems yet. We don't think about them yet. They haven't arrived to our country yet. Why we should be talking about them? Let's talk about the problems we face right now, right here. We don't have mental space. We don't have time to talk about things that don't exist here. So that's the problem, that it's really difficult for developing countries to try to devise solution to the problems that they don't have yet, or to the issues that their markets not yet facing. They have to be very forward thinking. And also, it's really, you can't even say that, we will be in the same situation like, US or Germany or somebody. Situation might be different, suitable for the future. So it's a difficult discussion to have. Keep in mind, like, different development levels in different countries. But well, certainly, the developing countries have to be, in any case, try to be more active in those discussions, need to prevent legal developments that are clearly, going to negatively affect them, the economies, their social being.
Thank you, Professor Rita. And Professor Paula, do you think this time as an opportunity to do some changes in the way we apply intellectual property law in Brazil?
Yes, I think we are facing very exciting times for property rights. We are in a no turning point, or we do something, or this concentration after the pandemic is going to present the bill, as we say in Portuguese. We are going to have problems, and everybody's talking about this concentration, political problems, dealing with democracy and environment, social problems. We are facing it now. Social problems are increasing all over the world. I think we will have to do something. If we want to do, we have to do it now. But the problem is, I really don't think that people or the mainstream want to do anything. And so I'm thinking about the death of antitrust, really, because antitrust, you can do a little bit here, a little bit there, but antitrust is doing nothing for us, or is doing very few. Sometimes in Europe, you have a fine. You take Google and you give Google a fine, or Microsoft a fine. In America, not even this, not even a good fine. But I don't see, even if we have fines, I don't see that Europe is strong enough to do something, because we are talking about American companies. Let's face it. And I don't know if, I think Europe would love to do something, even because they have different values. They believe in different things, not better or worse, but different things. But I don't see Europe strong enough to impose its will to America. And well, again, we are talking about American companies. and global problems. If Europeans can do anything, what should we say about developing countries? Okay. So let's wait and see. I'm a little bit pessimistic in this.
Thank you very much. I think we have cleared all the questions, all the discussions. Do Professor Rita or do Professor Paula want to say something before we end the panel?
I would just like to thank you again, Vinicius. You are great, just organizing two women talking and talking. So you were great on this. Thank you very much again. And again, you guys from IBCI are doing a great job. Thank you very much in my name and in the name of all our young people and students in this area. Thank you very much. Thank you, Rita. It was a pleasure. I'm going to send you all those decisions.
Thank you very much from my side too. It was also my pleasure to participate. I hope it will lead to further conversation with people in Brazil and elsewhere on these important topics.
Thank you very much, and thank you very much, Paula, for your words. And goodbye, everyone. Please stay tuned to new IBCI panels on today. Next one is going to be about regulatory agencies and judicial review. We're going to have Professor Paula Forgioi, Professor Luciane Jung, and Professor Felix Chang from University of Cincinnati. So, goodbye. Thank you very much.
Thank you, guys. Bye-bye.
Thank you.